welcome to ALN Thursday at 4. Thank you all for being here on this September 10th, 2020. I'm Nick Kanoki, the producer of ALN Thursday at 4. And behind me is Cirque in the Wind River Range, where I recently went rock climbing. If you have any questions during the webinar, the chat here, please put them in the chat and we'll get them answered at the end. And without further ado, Steve Carlin and Mike Bordenero.
Hi, thanks everyone for joining us, and special thanks to Steve Carlin, an ALN board member, who is stepping in for another ALN board member, Dominic Townsend, who had a last-minute conflict and was not able to speak with us as scheduled. We'll let you know when he will be joining us again, hopefully soon. And Steve is not only our board member, he is a lawyer. He is an adjunct professor at the Catholic University of America at the Columbus School of Law. And Steve has a class tonight, and thank you taking time away from your class prep. What's the class tonight about, Steve?
Actually, this evening's class is agency and partnership law, and it's really about issues of authority for employees, for contractors, independent contractors, things of that nature. And okay. So, you know, nobody can ever get enough of hearing lawyers talk, so I'm happy to contribute.
Well, what we would like to you to talk about is what we ask all of our guests to start off with is how did you get to this point in your asset management journey? How did you find your way to ALN?
Sure. Well, it's really kind of twofold. The short answer is through Jim Dieter. Jim and I have a mutual friend who is a roommate of mine from college who lives very near Jim, and they've been good friends for some time. And we moved up to the Northern Virginia area about 6 years ago so that my wife could pursue her dream job and I could pursue my dream of no longer having a job, at least as a practicing lawyer. And so we met that way. And as I got to know Jim Dieter, we started talking about a number of the different types of matters and issues that came up. My background is in commercial and corporate litigation of all kinds. What I'd like to say is it's really a complex litigation. Lots of litigation involving real estate, lots involving technology and computer services, some construction. And Jim and I started a discussion about kind of, you know, lessons learned, because I like to say that being a litigator is like being a professional accident witness. You come in after everything's already crashed and blown up and you try to piece back together, you know, what had occurred that led to this ultimately becoming a lawsuit. So Jim and I talked about this, and we would talk about various issues really just when we'd get together with our mutual friend over, you know, for a burger and a beer. But after a while, Jim asked me if I would consider joining the board of the Asset Leadership Network, just to really kind of give a fresh perspective from somebody who was dealing with these issues from a third-party outside perspective. And so that's what I've been doing. I've been on the board now for about a year and have found it to be a very interesting group of folks, all really kind of dedicated to the same proposition, which I think I ultimately became dedicated to, and that is to try to avoid problems, to figure out ways to prevent things from going into litigation. Because I'd like to say that if you're calling a litigator, it's kind of like calling a mortician. It's never really a fun thing. It's not for good reasons. You're either getting sued by somebody you don't think you should be sued by, or you're having to sue someone because they didn't perform or you think they didn't perform. So especially in probably the last 10 years of my practice, I actually started getting brought in on more advisory roles with transaction lawyers and clients to look over things before they closed a deal to see if, you know, if their language was clean enough and clear enough so that, you know, clients didn't want to spend a lot of money to close a deal only to buy themselves a lawsuit 6 months later. So I started to get more of an interest in that and kind of consulting on litigation avoidance, frankly.
Yes. So what have you learned from your involvement with the Asset Leadership Network about a contemporary approach to asset management?
Well, anything that provides professional standards provides stability and predictability. And when both sides to a transaction, regardless of whether it's about a building, about a piece of software, or about, really anything else, the more that they understand each other's positions, the more that they understand how they are operating, the less likely there is to be a dispute. You know, I used to say that if you give me a 150-page contract, I'll find you an argument. But if you give me a 5-page contract that is simply, cleanly, and professionally written, it's a lot harder because the expectations are more properly set between the parties as to how they're actually going to go forward. And what I see with ALN is a group that is dedicated to professionalizing the standards for how to acquire and manage and dispose of all different kinds of assets. And frankly, those are the kinds of matters that led to the disputes that I was involved in for close to 30 years.
So glad that you were able to talk with us today. We wanted to have you be involved at one of these chats, but what you just said was so good to hear. And I would like you to explain a little bit about your backgrounds and why you have them. And can you shift background for our audience?
You mean the virtual backgrounds in the Zoom? Yeah. Oh, I thought you meant about my personal background, because of course I can talk about that forever. No, I teach a class, and in fact, I'm teaching a class later this evening in agency and partnership law. And so one of the things I try to do, since my class in this age of the pandemic is not in person, but is over Zoom, my class is at Thursday night at 7:45 to 9:30. So I'm trying to keep people interested and engaged. So I play around with the virtual backgrounds and have a little ongoing trivia contest with my students between cases, where I will flash up a different background, say, of a different movie, and ask them to identify, you know, which movie I appear in. For example, this little image here, and I will offer a little reward to anyone who can identify what movie this particular scene appears from.
Okay, I knew The Simpsons, but I do not know this movie. If anybody wants to chat.
Yes, Amber Propert has got it for somebody. Amber Propert has got it immediately. Independence Day. That was quick, because this is a little lesser known scene. And since most of my students are younger, I frankly don't mind using some older movies that I'm not sure whether they've seen or not. But that was a good, quick response. I'm not sure my students this evening would respond as quickly. Okay, but I do that throughout the class.
I did not ask that just for fun, which it is, but I asked that because I think your approach to education is worth discussing. Keeping people engaged. Basically what the Asset Leadership Network is doing is providing professional education for people. We're sharing best practices and it's lessons learned, and it's our job to engage people in a way that's meaningful for them. And having some level of entertainment and fun is always meaningful for people. So
it
talk
is.
A little bit about your education approach?
Sure. Well, you know, having been a trial lawyer for 29 years, your job really is to be a teacher, because you're supposed to talk to a group of people, an average jury or an arbitration panel or a judge, who don't know and frankly don't care much about what your dispute's about. So, you know, we like to joke about it, but you at least need to make it entertaining or informative enough to keep them interested. You want people to be, to feel like they are being given a complete picture of the matter, and they're being given metaphors and analogies that they can relate to in their everyday lives. Because the more people can understand where you're coming from, the more they are going to remain engaged, and they're going to get a better perspective. And so that to me is one of the keys. One of the things I like to try to do in my classes, I teach another class called Business Torts, and I tell the students that's the fun, sexy one, because that's all the cases about the lying, cheating, and stealing, the fraud and tortious interference and theft of trade secrets. But is to really get behind the cases, to get a broader understanding and question not just the who, what, where, and when, but the why. Why did things end up the way they do? And when you can start thinking about the why does this other party want this particular provision? Or why is it so important that we on our side have this provision as we're contemplating entering into this agreement? That can give you a better understanding of what's really worth fighting for. I have a wonderful, beautiful, brilliant wife who is also a lawyer. And I get to tell people that in our family, we have 2 Harvard degrees. They're both hers, but I paid for the second one, so I like to take a little associated marital credit, because behind every great woman, there's a man trying to take some credit. But we have discussions about, and her background is as a transactional corporate lawyer, and we will have discussions about how best to frame something so that she could put together transactions for her company to avoid litigation, but also to make things clearer as to what the intent, what the real intent of both sides is, and so that each side has their expectations properly set. And that to me is what ALN does, because the broader these operating standards can be disseminated, then the more likely it is that you're going to end up with more and more professionals who understand better where the other side is coming from, what they're trying to do, and why they're trying to do it in a professional way that allows both parties to get the maximum benefit out of the transaction they're making, as opposed to wasting time nitpicking and fighting about things later.
So what can the ALN do to bring this type of information to the legal industry? Are there ways that we can participate in activities, or what are your thoughts on the way we can help prevent litigation by improving the transactional agreements in the first place?
Well, I think it would be worth pursuing maybe making presentations at some of the legal conferences, especially some of the continuing legal education conferences in particular practice areas. For example, an obvious one would be real estate, but another one would be intellectual property, and another would just be commercial transactions, so that the perspective that asset managers could bring to the table could help the lawyers better understand and have a more practical perspective of what the client not only wants to achieve, but what they should want to achieve. Because oftentimes the party that the lawyer is dealing with in-house at the client may not be the same person or the same group that's actually going to have to carry out and live with the contract that the parties make. And so the more that the lawyers understand the practical operating realities of the business, the better. For example, Mike, one of the things I always ask my clients to do when I got into a new lawsuit, especially when it was in an industry I hadn't been involved in before, was to give me a tour of the plant. I wanted to see how the widgets were made, or whatever the product or service was. I wanted to be able to know it soup to nuts, so that if there was a dispute over, during some litigation, I could tell the judge in that case, hey, Judge, I've been there. I see how the product is made. What they're describing isn't reality, and I can represent to you as an officer of the court that's just not right, because I've actually seen it. So in that sense, more information to the practicing lawyer is always better. More information about professional standards, about practical realities is always better. That way the lawyer can better advise their client. There's a reason why there's attorney-client privilege. And the reason is so that the client can fully and completely disclose to the lawyer everything, the good, the bad, and the ugly. That way the lawyer can give their best advice. If they don't have all the information, well, then the quality of the advice suffers. So ALN could bring additional information, additional professional standards and applications to the legal industry to better understand what their clients are trying to achieve.
Excellent. So we have a lot of people online who are involved in personal property, and I had been briefed prior to talking with you that personal property law goes back to Magna Carta, and I wondered if you have any experience in any personal property cases, or any insights on where personal property law is today.
Well, personal property law is what we would, in law school, they would refer to as the law of chattels, because personal property is separate from real property, which is obviously land. But personal property can encompass anything from, an actual physical object like your laptop computer, but also to your intellectual property, your trade secrets. That's personal property as well. And so, the law of personal property is fairly consistent from state to state. There are basically all kinds of tort law that will provide for the theft of personal property or the misuse of personal property. Not to mention there's obviously also criminal implications depending on what kinds of personal property are involved. For example, I had a case involving the sabotage of a software update for a very large company. And so there was actually a criminal intent to destroy the personal property of the client. And so that not only involved civil matters, and civil matters are primarily matters between private parties, and they primarily deal with the transfer of money damages. And they have a much lower burden of proof. It's preponderance of the evidence. And you hear these phrases and you hear beyond a reasonable doubt. Most people don't know what that means in terms of practical realities. Well, preponderance of the evidence is a 51 or 50.1 to 49.9 standard. Is it somewhat more likely than not that the plaintiff has proven their case? Mm-hmm. That's a lot easier burden to meet than a criminal standard where it's beyond a reasonable doubt. There you're talking about 95 to 99% right. Is what the prosecutors have to reach across and do. So most personal property issues might concern civil law. And so that's why the proper use of standards and the proper setting of expectations about the use of that personal property in the form of agreements and in the forms of the operating standards is going to reduce the amount of disputes that come up.
Okay, so I know you came up from Texas to Washington, D.C. Mm-hmm. Had you ever dealt with any government cases?
Oh, sure. I did a number of, for a long time, a very large foreign defense contractor, actually, but owned U.S. operations in Fort Worth, Texas, was a client of mine. And so we would have a number of issues come up. And of course, we would have a number of issues coming up over government contracting. Sometimes those could be direct disputes with the government itself, which has its own entire process for resolving those disputes established. But sometimes and most of the issues I dealt with would concern dealing with subcontractors who weren't performing mm-hmm. and could end up making the client fall behind on its schedule with the government or with the government contract that it was performing under. So I did have opportunities to deal with a number of government issues as well as some state government issues over things like traffic control software or construction disputes. For example, the construction of the Cowboys Stadium in 2009 was something involved where we were involved in a dispute with the city of Arlington on behalf of an apartment complex nearby. So I've dealt with a number of cases, both directly with the government on our side, directly with the government on the other side, and sometimes with the government as just a third party, but with a third party that had a very large lever hanging over the parties in dispute.
Right. What was the situation with the Arlington Stadium when the apartment?
Well, I guess I can tell you some of what's publicly available. That was where, when the city had established its traffic protocols for the new Cowboys Stadium, they were effectively going to lock these people in their apartments for the entire day, that they would not be allowed to enter or exit the premises of their own homes from something like 7 o'clock in the morning until 11 p.m. at night. So if they were in their apartment, they weren't going to be allowed to leave. And if they were out of their apartment, they weren't going to be allowed to get in. It's kind of ridiculous.
Yeah, that seems to be a denial of rights of your real property. So
yeah, well, we were successful in getting a temporary injunction from a federal judge in Fort Worth to stop the city from doing that, and then ultimately negotiated a resolution. But sometimes it's just an issue will come up like that where it's not intentional. It's just that nobody bothered to think about, hey, what's going to happen to these 1,200 residents of this apartment complex who are not going to be able to enter or leave on a quote unquote game day. And that didn't just apply to the 8 Sundays in the fall, because the Cowboy Stadium is used for literally hundreds of other events every year.
Yes.
It was going to apply many, many times a year.
Concerts and all kinds of activities.
Exactly.
So many of the things that you're talking about, I can kind of relate to chapter and verse in ISO 55001. ISO 55001 4.1, you shall have leadership involvement. Well, actually, that's 5.1. But 4.3 is involve all relevant stakeholders. And clearly your neighbors are relevant stakeholders. And if you involve them in that would have helped eliminate some of those problems.
Well, sure. In that case, if someone had bothered from higher up to look at and to at least pose the question of what impact will this traffic plan have on the community around us, if somebody had bothered to look beyond just the traffic flow in and out of the stadium and
Right.
consider the rest of the area, well then, the ultimate resolution would have been made before there was ever a lawsuit, and it would have saved, the better part of a year with the possible delay of the opening of the stadium, and hundreds of thousands of dollars of legal fees. If somebody had simply had the buy-in to ask the question, hey, wait a minute, guys, before we put this in place. And then, as you know, you run into the situation where once somebody has taken a position, you can get into internal bureaucracy issues of where nobody wants to take responsibility once there's a problem.
Right.
And that ends up leading to more litigation. So the involvement, as you point out, Mike, the involvement of leadership early on at a certain level to ask those kinds of broader questions can do so much to reduce the inefficiency and the potential disputes among the parties involved.
So ISO 55000 addresses both tangible property and intangible property. And our another board member, Rich Culbertson, is very strong in saying there needs to be done. We need to do more to apply ISO 55000 to intangible asset management. So that involves patents and copyrights and a lot of software activity. And you've been involved in software. What type of issues have you seen, and how do you think better intangible property asset management could help there?
Well, sure. The main issue that comes up is, it really breaks down to straight up patent infringement is fairly technical. Patent infringement is when a third party is going to claim that your product or your service, depending on how it was patented, violates a pre-existing patent. And that's a fairly standardized process. But the greater cause of most disputes tends to lapse over into theft of trade secrets or theft of confidential information or misuse of trade secrets and confidential information. This comes up an awful lot when employees leave a company and go to a new company. And did those companies properly communicate and understand what kinds of limits on use of information there are? For example, you may have seen, probably a couple of years ago now, there was a big dispute between Uber and Google, where somebody who was working on self-driving car technology at Uber set himself up a small third-party company, transferred most of the intellectual property, including gigabytes of it from Google's own servers, put it into the third company, and then went and sold the third company to Uber. And then Google and Uber got into a big fight. And you can go back and forth about what the particulars were, but in that case, you could really talk to both sides, Google and Uber, and say, wait a minute, guys, what are you doing in your systems and in your protection of your tangible property to make sure that, one, your tangible property isn't being taken and misused, or two, that somebody isn't bringing you property that they don't have proper rights to and don't have the right to bring to you? Because in that case, if you're Uber, all of a sudden you think you're buying this small independent third-party startup, when in fact it turns out that that data came from Google. And now you're in the fight of your life against one of the largest tech companies out there. Mm-hmm. And what did you do in your due diligence and in terms of your review to satisfy yourself that these people actually owned what they were proclaiming that they were going to bring to the table? So on both sides there, had they done more in terms of intellectual property protection for themselves, there wouldn't have been a dispute. Uber wouldn't have ever bought this stuff, and Google probably wouldn't have ever had it stolen.
Yeah, there's the whole human factor. As much as we want to plan and manage, we're not going to stop people from doing bad things. But,
well, and I think we need to assume that we like to try to pretend that we can create rules and policies that will eliminate the subjective. You can't do it. You can't take human nature out of the equation. I tell that to my students all the time when we're reading lawsuit legal opinions. And again, getting to the why. Why did the court rule this way? And sometimes it can be very result driven, where you can tell from reading an opinion, for example, the panel just really didn't like one side or the other. And so to think that we can eliminate subjectivity and the human factor, it's unrealistic. So what we have to do is plan for it and work with it and assume it's always going to be with us.
We've got to be smarter than the bad guys.
Right, right. But it also means you don't have to write a new policy just because one person did something dumb, right? You don't want to kill yourself by writing too many rules down and too many detailed policies. If you give somebody a 200-page policy manual, how likely are they to actually read it, as opposed to giving them a 10-page policy manual? And so we used to have these kinds of debates with clients all the time of, if you are doing a better job of managing your human capital and your human assets, you're actually going to reduce your litigation exposure.
Well, very good. I believe we're coming to the point where we ask questions. And
Okay.
so Nick should be joining us.
Hey guys, thanks so much for being here, Steve. It's been really fun to listen into you.
Oh, there's nothing like listening to a lawyer, right, Nick?
I've done
Can't
it
get enough of
before,
it.
but you were one of my favorites to listen to, I would say. There was a question about, is there a case that you were a part of that, that could have used better asset management to prevent litigation?
Oh my gosh. There's a lot of them. I can tell you about a case of for example, the construction of a luxury multi-million-dollar condominium complex where each condo was unfinished, was priced at a couple of $1 million. And when the building was done, they figured out in the worst possible way that no what are called penetration sleeves had been put on each of the wiring and piping penetrations that go up from floor to floor. And those sleeves literally surround them at the bottom so that if anything floods on any given floor, it won't go down to the lower floors. Well, there were no sleeves in this entire building, and someone's washing machine flooded over on the 17th floor, and the water went down to the lobby. And it did things like ruin someone's multi-million-dollar Renoir painting and somebody else's 15th century Spanish leather wall coverings, right? And it ended up being a years-long piece of litigation involving all of these parties. And so had there been better management of the project itself in terms of the quality of review standards, there would never have been a lawsuit. It was through a series of, if you've ever read the books concerning the sinking of the Titanic, it reminds me of, there's one called A Night to Remember. What that really was all about was failures to communicate in numerous levels among the passengers, among the crew and the passengers, among the other ships and the crew. And so in that case I just described, it was really failures to communicate. And it was irreparable because short of tearing the entire building down, you couldn't go and put in those penetration sleeves on all 17 floors. So yes, most of the cases that I dealt with concerned failures of asset management.
Okay.
Awesome. Well, that's quite a statement.
We got time for one more question, Nick.
Okay, yeah, and there was a question whether or not you had any dealings with famous musicians in your career, Steve? A blues musician?
Yes, I'm kind of curious about who might be asking that question. I had the pleasure of representing Stevie Ray Vaughan for about a year before he passed away. He was in a dispute with a former manager who had actually been probably a supplier of drugs to him before he had gotten clean, and this person was suing him. Unfortunately, Stevie died in the helicopter crash while the lawsuit was still going on. We did ultimately get it resolved through help from his brother Jimmy and his mother, but I did. A true gentleman, a very nice guy, unbelievably talented guy, but an unbelievably humble, quiet gentleman. It was a true pleasure to deal with him.
Wow, humble and quiet. That's very different than the very loud and raucous music he played.
Well, I can tell you quickly, when the first time he came into my office, he showed up at the lobby and the receptionist called up to me and said, "Steve, there's a Mr. Vaughn here to see you." And I said, "Okay, that's fine." And she said, "Are you sure you're expecting him?" I said, "Yeah." And she asked that question because he was wearing these jeans that were not pre-torn. They were worn through at the knees and other plots. And he had about an old like Texaco t-shirt on and several days of growth. So she had no idea who he was. And he came back and he sat down and we were just chatting and I was trying to make him feel comfortable. So I asked him about his hat band because he was wearing his trademark flat brimmed hat. and he had a very nice hat band around the top of the hat. And he said, yeah, he's very quietly said, yeah, the record company gave it to me when, what was it, Texas Flood went platinum or something like that. And it occurred to me, I said, wait a minute, I thought that was cubic zirconium. Are those diamonds? And he said, yeah, they are. And I said, what are you doing walking around downtown Dallas with, $100,000 worth of diamonds on your head? And he literally said to me, he goes, well, the rest of my outfit's worth about $6. Who's going to think these are real? Like, okay, that's a good point. And he's like, what else am I going to do with it? So it does, you run into some interesting people.
Yeah. Well, thank you so much for being here, Steve. We are out of time and we want to respect that. So yeah, if you guys want to do your closing salutations, I'll play the closing slides and we'll be done.
Yeah, thank you, Steve. And thanks to everyone for watching.
Thanks very much for having me. Have a great weekend, guys, and everybody else.
Okay, thanks again for being here, Steve Carlin. And thanks, of course, to our organizational members. Without them, it wouldn't be possible. And the production team, as you see, myself, Mike, and Jim Dieter. Thanks to us all. And we'll see you next week. And if you want to continue this conversation, please feel free to reach out to any of us personally or send us an email at webinar@assetleadership.net. Thanks.